Hi, I'm Anna Denton-Jones of Refreshing Law, and in this session I want to talk about employees and second jobs. I've already posted a video about this once, and those videos are normally made for my clients to include in my newsletter, but a byproduct of that is that the videos do sit on YouTube, which gives people the opportunity to comment on them. And I would say I've got the most trolling kind of response to that post where I was talking about employers and the desire to perhaps restrict somebody in terms of second jobs, which tells me that it's something that employees don't necessarily understand why their employer might want to put restrictions in place. Secondly, we've got the cost of living crisis affecting employees and employers. I know lots of employers are thinking about ways in which they can start to support their employees, and employees obviously are focused on sources of further income, considering whether or not they might be able to squeeze in performing a second role in order to increase their income. So it's definitely something that people are talking about. A recent survey showed that 38% of staff are thinking of secondary employment. So it's something that if you haven't as an employer been addressing, then maybe you need to start thinking about. So to go back and set the scene, in the absence of anything written down, then there's going to be an implied term in the contract of employment that the employee owes their employer, obviously, fidelity during that contract of employment. So that's going to mean, not doing anything in competition with that employer or diverting any opportunities. But essentially, if you've agreed to work certain hours for your employer in the absence of something in more detail, then potentially as an employee you could be taking on secondary employment outside of that primary employment, provided of course it's not going to put you in breach of those duties of fidelity. Many employers go beyond that and have strict rules in the contract of employment, so express terms that set out perhaps that you can't have secondary interests without express permission from the employer. I certainly had an employer who during the pandemic allowed a member of staff to pursue, if you like, a side hobby as part alongside her job, because it didn't conflict with what the employer does. They didn't mind her having that secondary interest. But when they gave their permission for that, there wasn't really enough discussion around what it was going to involve, how much time it was going to involve, whether it could become a gross distraction for the employee, which of course it was very successful, and it started to become something that the employee was spending more and more time doing in circumstances where the employer was starting to feel as though it was having a negative impact on the day job, if you like. So where an employer does allow secondary employment, employees shouldn't be surprised if the employer wants to put, if you like, guardrails in place around what permission looks like. So how many hours, that it's all taking place outside of the normal working day. There's no temptation to start doing tasks during the working day when you're supposed to be concentrating, if you like, for the first employer. They didn't really do that, and then you start to get niggles and issues arising as a result. So if you are minded to let employees have secondary employment, then I'd be thinking about what those guardrails, what any policy, if you like, should say. From a legal position, employers have got to think around things like health and safety. If somebody's working lots of hours, are they going to be safe then when they are driving the forklift truck or operating machinery? So working time regulations set out rules around numbers of working hours and also around rest breaks. Now, when it comes to the total number of working hours, often we get people to actually opt out of that limit, but it is worth thinking about what the pattern is going to look like and how much rest somebody is getting and where it's going to start having an issue. So whilst it's possible to contract out of that ultimate cap on number of working hours in the week, whether or not that's sensible or not is obviously something to be discussed, but the actual rest breaks that should make up the pattern, if you like, within those weeks isn't something that you can contract out of. So if somebody does have a second job, are they getting enough weekly rest? Are they getting enough daily rest? So between the time that they go home from the employer and they arrive again the next day, is there enough rest happening? There is case law that suggests that where an employee is doing something voluntarily, employers aren't likely to get clobbered for that. But it is still worth thinking about, because if the person crashes the forklift or operates the machinery in an unsafe way and does harm either to themselves or to somebody else, then it is going to become the employer's issue. If you've got any questions on that subject, please do let me know. It's adenton@refreshinglawltd.co.uk.